Hello students. Today we will be talking about the protection of accused person under the Indian laws. Now the term accused has not been specifically defined in the Constitution of India or Code of Criminal Procedure. But what we generally understand in common parlance or in the context of criminal justice administration is that the accused means the person charged with the infringement of the law for which he is liable and convicted, then punished. In other words, accused is a person who is charged with the commission of offence. Now, the criminal justice system in India has tried to strike a balance between the rights of the accused as well as the rights of the victim and society at large. The burden of proving the guilt of the accused is always on the prosecution, and in case of any doubt, the accused would get the benefit of doubt. The well recognized principles of criminal justice administration, namely the presumption of innocence, right to silence and the right to fair trial, has brought the protections of accused persons in India at par with the international standards. It is often said that the criminal jurisprudence is aligned towards the accused. Before trying to explain the various rights of the accused under Indian laws, it will be proper to first explain the meaning of accused. A person would become an accused if a complaint or a formal accusation has been made against him, who in normal course would result in prosecution. Protections available to the accused can be classified in various categories. Now, we have a pre-trial protections. The prohibition on arbitrary arrest and detention, which comes under Article 21 of the Constitution of India, provides that no person shall be deprived of his life or personal liberty except in accordance with the procedure established by law. The Supreme Court of India, in the famous Gopalan's case, held that the protection under Article 21 is available only against arbitrary execution action and not against arbitrary legislative action. It clarified that if personal liberty of an individual is taken away by a law, the validity of the law cannot be questioned. However, in the Maneka Gandhi case, the Supreme Court overruled its judgment in the Gopalan's case by widely interpreting Article 21. It stated that protection under Article 21 should be available not only against arbitrary executive action, but also against arbitrary legislative action. It pronounced that the expression personal liberty in Article 21 is of the widest amplitude, and it covers a wide range of rights that go to constitute the personal liberties of a man. Similarly, Article 22 provides safeguards and protects individual from arbitrary arrest and detention. Its various clauses declare that no person who is arrested shall be detained in custody without being informed of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his own choice. Then every person who is arrested and detained in custody shall be produced before the nearest court of the magistrate within 24 hours, excluding the journey time, and no such person shall be detained in custody beyond the set period without the authority of a magistrate. Right against self-incrimination. In adversarial trial system, the burden of proving the guilt is entirely on the prosecution, and the law does not call for the accused to lead evidence to prove his innocence. Yet, the accused is given a right to disprove the prosecution case or to prove special defense available to him. The prohibition of torture and the right to humane conditions during pre-trial detention. Police has a legal duty and has legitimate right to arrest a criminal and to interrogate him during the investigation of an offence. But law does not permit use of torture of accused in custody during investigation or interrogation. Use of third-degree methods or any form of torture to extract information is not permitted. According to section 330 and 331 of IPC, physical torture of an accused during an interrogation is an offence and hence punishable by 7 to 10 years imprisonment. Examination of arrested person by medical practitioner at the request of the arrested person. According to section 54 of CRPC 1973, when a person who is arrested, whether on a charge or otherwise, alleges at the time when he is produced before a magistrate or at any time during the period of his detention in custody, that the examination of his body will afford evidence which will disprove the commission by him of any offence or which will establish the commission by any other person of any offence against his body, the magistrate shall, if requested by the arrested person, directs the examination of the body of such person by a registered medical practitioner. However, if the magistrate considers that the request is made for the purpose of vexation or delay or for defeating the ends of justice, he can refuse such medical examination. Then there is a right to a prompt appearance before a magistrate to challenge the lawfulness of arrest and detention. Whenever any person is arrested and is detained in custody, and it appears that the investigation cannot be completed within the period of 24 hours fixed by section 57, and there are grounds for believing that the accusation or information is well founded, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest judicial magistrate a copy of the entries in the diary prescribed relating to the case, and shall at the same time forward the accused to such magistrate. Now, it will be very relevant to mention the guidelines issued by the Supreme Court in D.K. Basu versus State of West Bengal. It was there that the Honorable Supreme Court issued the following guidelines. The arrested or detained person is entitled to inform a friend, relative or any other person interested in his welfare regarding the place of detention and the reason of arrest as soon as practicable. The arrested person must be made aware of this right as soon as he is arrested or detained. The arrested person may be allowed to meet his lawyer during interrogation but not throughout the interrogation. The arrested person should be examined by a medical doctor at the time of arrest if he so requests. All bodily injuries on the arrested person should be recorded in the inspection memo, which should be signed by both the arrested person and the police officer making the arrest. A copy of the memo should be provided to the arrested person. In Prem Shankar Shukla versus Delhi Administration, the Honorable Supreme Court observed that using handcuffs and fetters that are chains on prisoners violates the guarantee of basic human dignity. It should be used only in exceptional circumstances. It issued the guidelines regarding the use of handcuffs. During criminal prosecution, there is a right to be presumed innocent. The right to be presumed innocent until proved guilty is a principle that in fact determines the treatment to which an accused person is subjected throughout the period of criminal investigation and trial procedures. Presumption of innocence means a person cannot be presumed guilty. It is for the state to produce evidence of guilt. In general, therefore, a suspect's silence should not be used as evidence of guilt. However, there are certain exceptions to this law. For example, Section 114A of the Indian Evidence Act 1872. It states that in a prosecution for rape under Clause A or Clause B or Clause C or Clause D or Clause E or Clause G of Section 376 of the Indian Penal Code, where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and she states in her evidence before the court that she did not consent, the court shall presume that she did not consent. Similarly, when the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death, such woman had been subjected by such person to cruelty or harassment for or in connection with any demand for dowry, the court shall presume that such a person had caused the dowry death. Then we have protection from double jeopardy. Article 20, Clause 2 of the Constitution of India provides that no person shall be prosecuted and punished for the same offence more than once. Under the provisions of the Indian Constitution, the conditions that have to be satisfied for raising the protection are: firstly, there must be a person accused of an offence. Secondly, the proceeding or the prosecution should have taken place before a court or a judicial tribunal in reference to the law which creates offences. And thirdly, the accused should be convicted in the earlier proceedings. Now, the application of the principle came up before the Supreme Court in the case of Maqbool Hussain versus State of Bombay. In this case, the appellant, an Indian citizen, was arrested in the airport for the illegal possession of gold under the provision of the Sea Customs Act 1878. Thereupon, an action was taken under Section 167 Clause 8 of this Act, and the gold was confiscated. Sometimes afterwards, he was charge sheeted before the court of the Chief Presidency Magistrate under Section 8 of the Foreign Exchange Regulation Act 1947. At the trial, the appellant raised the plea of doctrine of double jeopardy. He sought the constitutional protection mainly on the ground that he had already been prosecuted and punished in as much as his gold has been confiscated by the customs authorities. The court rejected his plea and held that the proceedings of the sea customs authorities cannot be considered as a judicial proceedings because it is not a court or judicial tribunal, and the adjudgment of confiscation or the increased rate of duty or penalty under the provision of the Sea Customs Act does not constitute a judgment or order of a court or judicial tribunal. Then we have a right to cross-examine the prosecution witness. Now, the art of cross-examination is the most effective weapon for the discovery of truth, provided the objective is not to confound or truthful witness, but to extract truth from an unwilling witness. Cross-examination is a feature of the adversarial process and designed to let a party confront and undermine the other party's case by exposing deficiencies in a witness's testimony. The prosecution must inform the defense of the witnesses it intends to call at a trial within a reasonable time prior to the trial, so that the accused has a reasonable time to prepare for his cross-examination. Now, where the trial court commits a serious error in disallowing the cross-examination of a prosecution witness on a very material point, it is not possible to accept the evidence untested by cross-examination. Post-trial rights. The right to appeal. The purpose of providing the right to appeal is aimed to provide an opportunity of judicial scrutiny of a case by the higher court. It is well known that an appeal is a creature of statute and there can be no inherent right of appeal from any judgment or determination unless an appeal is expressly provided by the law itself. Generally speaking, and subject to reasonable exceptions, at least a single right of appeal on facts where criminal conviction is going to result with long loss of liberty is basic to the administration of criminal justice. The right to appeal belongs to all persons convicted of a crime regardless of the severity of the offence and of the sentence pronounced in the first instance. Now, let me conclude by saying that the standards against which a trial is to be assessed in terms of fairness are numerous, complex, and constantly evolving. However, the most important rights to which the accused is entitled to have been enumerated earlier, criminal trial generally takes long time to reach to its logical conclusion. Section 309 of CRPC requires that in every inquiry or trial, the proceedings shall be held as expeditiously as possible. And in particular, when the examination of witnesses has once begun, the same shall be continued from day to day until all the witnesses in attendance have been examined, unless the court finds the adjournment of the same beyond the following date to be necessary for reasons to be recorded. though it cannot be technically called to be an accused's right. However, in Husainara Khatun 1980 versus State of Bihar, the Supreme Court has considered it to be an essential element of a fair trial to which accused is entitled to. Thank you very much.